We're here at the fantastic offices. I'm really sorry that you can't see the magnificent artwork over there, but of our colleagues here at Bristows. And with us are Louise Eldridge, who is the corporate partner, or is the partner in the corporate team, and Chris Holden, who is the partner in the commercial IT team. So thank you very much for agreeing to do this Ask Me Anything session, and it'd be great to hear first about what you do at Bristows.
Certainly. Well, it's a pleasure. Thank you, firstly, Tanya, for having us. My name is Louise Eldridge. I'm a partner in the corporate team, as Tanya said, here at Bristows. Just to give you a quick overview, for those who aren't familiar, Bristows is a leading law firm in London, based here in London, with very international reach, although we're based here out of the one office here in London. We're approximately 40 partners and comprising a whole range of legal services for and companies from very early stage right through their life cycle to the sort of very large, big household names. So we do the full spectrum. We've got a bit of an overview here for you to have a look at. We've been around for a while, since 1837, and we've always had a very strong connection with innovation and innovative clients. So right from the very early days of the firm's inception through to the kind of work that we're doing now. So we have a particular focus on IP-rich businesses, particularly in technology sectors, TMT, life sciences, consumer products and international markets. So we have, I think, the largest IP practice in Europe. I think that's still the case. And so it's very much focused on those IP-rich businesses. And again, across, if we could just flick through to the next slide, we've got a whole range of different areas there that we cover, from commercial intellectual property, which is Chris's area, and he can talk a little bit about that, through to what I do in the corporate team, and then covering all the things that you'd expect from employment, tax, litigation, disputes and so forth. And then just sort of flicking through on the corporate team, sort of stuff that I tend to get involved in is early sort of share structuring scenarios, fundraising events for early stage companies. So from right at the start with their initial early stage rounds, again, right through to the really big, Series C, Series D investment rounds. And then for those larger companies as they're growing, doing strategic acquisitions and so forth. And then that's us on the corporate side. On the commercial side.
Hi, good afternoon, everyone. As Tanya said, my name is Chris Holden. I am a partner in the commercial IP department, and we have 7 partners and another 14 or so associates across the IP and IT sectors. The bit that I do mainly is IT, but we have a very large commercial IP practice, 3 dedicated partners, and they spend a lot of their time doing quite complex licensing arrangements for a lot of life sciences clients, a lot of electronics clients. But across my bit, the commercial IT bit, which I think might be on the next slide, I concentrate on providing advice to clients around commercial IT side of things. So large scale IT transactions, outsourcing transactions, that's IT infrastructure, and also business process outsourcing transactions. We have a large data privacy practice and cyber crimes practice. We do a lot of digital online work, working with a lot of media companies, and also of late, the last couple of years, I have been leading the robotics and AI practice for Bristows, and we're heavily involved in that very technology focused commercial area. So everything from large scale IT deals, software licensing, non-disclosure agreements, hardware purchasing, all the way through from both public sector clients and private sector clients, suppliers and customers. So both sides of that particular fence.
And that's just a very quick overview, just to give you a bit of flavour.
Well, thank you both, because I think that gives us the context we need. Hopefully this is going to stop sharing in just a second. Oops.
exit.
Did I?
No, maybe you should.
Yeah. And bear with me, everyone. There we are. Thank you. Sorry about that. It's somebody else's technology, and I've been entrusted with the mouse. And those of you who know me know that is never a good idea. I never give me the microphone or the mouse. So, no, seriously, thank you very much for that introduction. I think it gives us the context we need for some of the questions that we've been getting. Of particular importance, of course, is, well, both areas are really interesting. Louise, you've worked with some small companies that have really scaled, and I think we'd like to hear a little bit more about some of the things that you've seen in their stage, from setting up the company, getting those early stage agreements in place, and the importance of that for later stages, like Series C, Series D. That's serious money.
Yes, it is.
And Chris, I think everything that you've mentioned from NDA is clearly something that is very, very interesting for our startups. But also, you mentioned your expertise in robotics and AI. Now, we have a number of startups operating with artificial intelligence and platforms.
Yep.
And one of the things that I'd like to speak to you in just a second is how that differs maybe from some of the kind of the normal, or what you've had to deal with with previous IT infrastructures, where you had maybe platforms and risk was perhaps more contained and layered. So Louise, back to you. So you've advised some small companies that have grown extremely, large. They're very well known.
Yes.
So what are the kind of issues that they've had to deal with in that stage of growth?
There are a multitude of issues, but we commonly see the same things that crop up time and time again. One of the things that we say to our really early stage clients is, you have to think with a long-term view. So you have to think about your funding round, the next funding round. If you haven't done one, your first one, and if you've done one, then the more money you take, the more serious the investor, the more scrutiny they will place on the due diligence aspect of looking at your business and before they put some money in. So the key thing we say is get your house in order, spend a little bit of time in the very early stages to make sure that what you're doing has a process to it, and that's everything from making sure you actually get the contract signed. It sounds silly, but things get overlooked as businesses are having to move quite quickly in the early stages and just get deals done because time's money. Those sorts of things can be critical. Making sure that you've got some kind of online repository where you put your contracts, making sure that your IP is protected, and I know Chris will probably talk about this a little bit as well, but really simplistic stuff around making sure that you don't give it away when you're talking to people, dealing with companies inadvertently, effectively, by signing up to something that's got some small print in there. We would say, look at your contracts with your web developers. If you're outsourcing, web development, make sure that those, even if you pay for it, it doesn't necessarily mean you own it. Make sure that you've got proper assignments in place.
Can I just delve into that a little deeper, because I know for a fact many of our startups are now at that stage where they definitely have technological expertise themselves, but there's always some part of the work that they outsource just to basically fast track and make sure so that they don't have huge wage bills.
Of course,
and that they need to get from idea to prototype to market really quickly. So outsourcing is something that many of them will be very familiar with.
It happens, certainly. And obviously it depends in which jurisdiction you're operating, because the law may differ. But if we take the UK, if we take the law of England and Wales, where Chris and I are qualified, then the starting point is that if you've got an employee, then if something is created during the course of that employee's employment, then the IP will belong to the company. The opposite is true where you're dealing with consultants, for example. So if you haven't got an employee, but you've got somebody who's contracting so many hours a week, then they will automatically, by law, own that intellectual property that they create for you, unless you have an effective assignment in place in a, it can be a very short, simple one-pager if you like, but you need something to protect yourself going forward.
Absolutely. I mean, even from an employment perspective, it's a great idea to have an employment contract which sets out the rights and obligations of you as the employer, of the employee. Within that, as Louise mentioned, intellectual property rights will be dealt with, so inventions made and copyright produced will be owned by the company. But if you're employing a load of contractors from various parts of the world, what you need to do is have an English law contract which says what you produce for me, I will own. You will send over the code, you will put it on you will send it remotely, you put it on a CD-ROM, you put it on a memory stick, you'll send it to me, this is the version, and I own it. And there's no, again, as Louise mentioned, there's no interrelationship between payment of money and ownership. So it's very important, very important.
I think that's a really interesting point to make, and I'm sure that many of our startups will be making notes of that particular piece of advice.
And we quite often find that we come to a significant kind of event for a company, and let's say it's an investment round, or even much further on in their life cycle, if they're coming to exit and they're selling their company, we've seen it be an issue where clients have had to retrospectively try and paper this and go find the people who did this piece of work for them to get them to waive their rights in any IP that's been created. So it sounds like, oh, it wasn't a big deal, it was just this, but actually it can come home to roost many years later, and you're trying to get in touch with somebody who you haven't spoken to for.
What's the value of the company? I mean, where does the value lie? It lies in a lot of IP that's been generated. It lies in it lies in the customer contracts that people have. And again, we see a lot of situations where startups don't sign contracts with customers. It's all done on a wink and a nod, and yet an investor is looking at the value in that company. So where is the sales contract? Where is the services contract? Where is the IP assignment? How are you dealing with all of your data? Where is it held? Who's hosting it? And it's that type of documented evidence that will add to the value. It won't detract from the value, and this is all done badly, but it will add to the value.
Yes, you say that. It can do, certainly on an exit scenario where if we see deals fall over because they haven't properly papered something, and they've taken some shortcuts, and we've seen it many times where had something just been a little bit of time and attention brought to something in the early stages, it would have saved a lot more money and time later on, and also stopped a buyer trying to chip away at the price because they think you haven't got your house in order.
I think that's very interesting because, Chris, we frequently hear investors tell our startups certainly that the value is the founders themselves, what they're investing is the team, and that is a very nice thing to hear, and it bolsters people's confidence, and to a certain degree it's to a large degree it's true. Without those founders there is no company. Even if there is IP, you need to put that IP into the market and make it basically work for you and monetize it. But what you're saying is you have to have a paper trail there, which is a real pain in the neck for I know that a lot of them will be thinking this, but at the end of the day, it's going to be relevant in the case, and of course there's going to be a case for all of them there, that there's going to be an exit. So it's a very good advice there. Louise, coming back to you now, with startups, they've got very broad shoulders. They carry the weight of the world on those shoulders, and they have to deal with 100 different things all at the same time. How much contact do they need to have with their lawyers at this particular point in the early stages?
So it will vary depending on the business and depending on the makeup of the team and their prior experience, typically. But we would encourage startups, even at a very early stage, to develop good relationships with their lawyers. If they haven't got lawyers, ask for recommendations from other entrepreneurs that they work with, or from their investors if they've already taken investment. For us, I think we can safely say that the clients that we're closest to, in so far as we know sort of what's on the horizon for them, are better equipped to deal with those events in an efficient manner. So clearly you haven't got a lot of money to spend on legal fees when you're a startup, but most lawyers will sit down and have a cup of coffee off the meter and get to know a potential client and say, you know, where are you at? Here's a list of headline things that you might want to think about, and you could put that one off for a while because you can't, you know, for cash flow purposes, you probably need to deal with this one quite quickly, and help you kind of plan where you are. And then you can, you know, you can look at a risk assessment of, well, actually, I really need to do that because that's where the money sits and our liability, you know, is higher if we don't deal with that, or whatever it may be. But I think our advice would be, take some time to actually just establish a relationship, and then you can try and roadmap what you have in front of you and work out what your budget is for legal and
most lawyers worth their salt who operate in this area have done a large number of these transactions before. So to a certain extent, it's old hat for us. If you are a website business, or you're a business with a website, you're going to need website terms and conditions, you're going to need privacy policies, you're going to need cookie policies. If you're selling goods and services, you're going to need sales agreements, you're going to need license agreements. So it's all part and parcel of thinking about what it is you're doing, where your markets are, what you're selling, how you're selling it, how you want to realize cash, how you want to protect the goods and services that you're selling, whether it's an IP-based thing or generally whether it's just a piece of hardware. It's just making sure that you have all of those arrangements in place at the beginning. You know, not entering into deals with people and giving away things, because that would be counterproductive.
Absolutely, as Louise said, it affects the value of the company further down the line. So just moving now on to the focus of the AMA, a lot of our startups are dealing with corporates. So we have B2C companies, we've got B2B, we've got B2B2C, and they've all in a very, very different positions and stages of negotiation with those corporates. But at what point do you think it would be interesting for them to actually involve a lawyer in those negotiations? Because clearly you can't go initially to a meeting with a large organisation that's thinking about whether they want to enter into some kind of contractual relationship and say, oh, here, I've got my lawyer with me. So how would you...
It's never a bad thing. They're not nasty people.
Yeah.
It depends. I mean, if you're dealing with very large corporates, you'll probably be dealing with a procurement department that will have a set of standard terms and conditions. And yes, marching in with a crowd of lawyers might be seen as being aggressive, but at the flip side of that, it might be seen by corporates as good planning. This is a series of people that are taking this seriously. But in reality, what usually happens is that we get involved after the commercial deal has been done. However, on many an occasion, I've sat in rooms and said, have you thought about this from a commercial perspective? Have you thought about the tax implications of what you're trying to do? No. So there are commercial things that we know because we've seen it all before, but usually after the deal has been done, there is a question of, right, this is what we've decided to do. Here's the standard procurement piece of paper that we've received from Exco. Can you have a look and tell us whether it's acceptable to sign or not? Okay. And usually it's the same old bits within those contracts that are problematical. There's the IP side of things, the confidential information type of things, the limitation of liability and the risk issues if things go wrong, insurance capabilities, the term. So you can look through these things pretty quickly and say, well, do you want to do this? Do you want to enter into a 10-year exclusive sales agreement?
That one's actually quite common.
Yeah, yes. And you will give me the ownership for everything you provide me. No. You will have 10 zillion pounds worth of liability if anything happens. No. So it's the same kind of issues.
That's a really interesting one. So actually, even though they don't necessarily have to take you into the meeting, when there is a contractual document, that's when they should definitely come to their lawyers and say, look over these terms, tell me what's behind them, because of course legal speak is a lot clearer, I think, than it used to be many years ago, but even still there are things there that somebody who's not well versed in whatever legal system,
not legally trained,
It's no longer in Latin.
Yes.
Yes, no longer in Latin.
As near as makes a difference.
Yeah.
And depending on the transaction, I mean, quite often I see a client will go off, have those commercial discussions, as Chris says, and then there'll be a heads of terms or a memorandum of understanding drawn up, but not signed at this stage. And then you get sent a copy of that. This is what we're looking at. And then you have an opportunity to say, okay, but you can't agree to that because you'll have an adverse tax consequence as a result, or you get an opportunity to actually provide some input at that stage before they sign the heads of terms that then informs the drafting of the more lengthy, meatier documents down the line. So, and that's often quite useful because then we can help.
That's the negotiating stage, proper then, I suppose. And Louise, you've brought up something that again a lot of our startups will have encountered, and that's a memorandum of understanding, which signals that both parties are serious about proceeding in their negotiations. What's the legal validity really of an MOU? I mean, it's a funny animal, isn't it? It's not.
It all depends.
It is.
Okay.
It all depends. I mean.
That's a very
I'm sitting right on the fence there. It does all depend because you can see many versions. You can see an MOU, which is a fully binding legal document. You can see MOUs that are not binding in the slightest, and then you see MOUs where some of it is binding, some of it isn't. Yeah. So it can be, at its simplest form, it's a let's record what we think are the commercial understandings and agreements between us, and you could as both parties could well sit down and say, look, this is just us recording things. We are in negotiations. Let's record again that this is not a legally binding document, and it's just us thinking out loud and putting it in paper. But this is what we're working off. If there are more complex things that need to be put down, then you would probably want to make those parts of the MOU binding, like confidentiality. You mentioned NDAs, non-disclosure agreements, right at the start, and it's not uncommon to see those types of clauses end up in a memorandum of understanding, so that everyone knows that the very fact that you're talking is confidential as between the parties. So it just depends on what the parties decide.
And costs is typically one as well, where parties set out who's responsible for the costs, and if there's a dispute, then the jurisdiction that's going to govern that dispute, that typically will be an enforceable clause within that, even if the rest is considered to be non-legally binding.
In corporate deals, they're usually binding, aren't they? Is that generally the way it works?
It depends. It depends. We'll have again. It depends on the type of transaction. So you'll have exclusivity often in there on a sort of corporate deal. There may be non-solicitation, non-poaching clauses that will consider to be legally binding, so that even if the deal falls away and you stop talking, you can't go and steal the employees that have impressed you and you've been negotiating across the table. So the devil's in the detail of the wording, because there is no one size fits all effectively.
So you've both brought up a couple of times things that are very close to the heart again of our founders, and those are NDAs. So we've got a question from Mark Bennett in Scaleup. So his experience is that NDAs can add an awkwardness and infer a lack of trust early in a relationship. Is there a middle ground between best practice and practicality?
I don't know about a middle ground, but I would question the awkwardness thing. I think most mature organisations realise that if you are a startup and you have a certain amount of IP or ideas that you would like to protect, then actually it's a professional approach to come in and say to people, Yeah, I'm very keen to talk to you. Obviously, there's a lot of new things that I'm working on, and so I would like to have all of this subject to a non-disclosure agreement, and I'm sure you would as well, because we'll be chatting about your organisation as much as we'll be chatting about my organisation. So I think it's a two-way thing. Maybe that is the middle ground. Make it two-way. Make it
it's a mutual NDA.
It's a mutual NDA.
Yeah.
I'm hearing about you. You're hearing about me. Let's make this a mutual NDA, and of course, those obligations, those words can be made mutual very, very easily. But I don't think people should feel awkward about protecting their business. I mean, if you ask that question of anybody, do you think it's wrong to protect your business? Everyone will say, of course. That's why wouldn't I do that? So I would always forget about the awkwardness. Protect your business.
Yeah. Okay. I suppose that the question there might arise if it's different in different cultures, but I think in those cases it's a question of tact and suggesting, as you said, that the element of mutuality should come into it, so that it lifts it out of that, lack of trust or perceived lack of trust.
I think the cultural thing is a very good point. Japan, lawyers play a very limited role in a lot of business deals. I mean, some Japanese agreements, whereas we'd have hundreds of pages, Japanese agreements are 3 or 4. In some of the Middle Eastern cultures, there are lawyers. It doesn't happen that way. It happens in a different way. Western economies, Anglo-Saxon type approaches are different. We like to record our agreements on bits of paper, but it's different. France is different to Germany, Germany different to UK. But there are cultures that it's completely different.
But I agree with Chris. I don't think there should be a hesitation about feeling awkward about putting forward an NDA. I think it's very common. I think in some cases there may be some pushback from, depending on who you're dealing with. If you're dealing with another commercial entity, then it's very common. If you're putting it forward to a very well-established VC firm, there may be some pushback there, because VCs
that they don't sign them
typically don't feel that they need to sign up to an NDA. And it'll differ case by case, but most VCs are not in the market of trying to pinch other people's business ideas, and will be a bit more resistant to signing up.
From the conversations we've had with VCs, they'll say, look, we come across hundreds of ideas. It's impossible for us to sign an NDA because we'd open ourselves to all sorts of liabilities there.
Exactly.
There is the law of confidence in England and Wales, and that doesn't require bits of paper to change hands. It's just a question of proof. An agreement that says we'll both do these things and we'll treat our information as being confidential is proof, because both parties have signed it. But if you record, not press a button, but after an event, you record on a piece of, I went to see so and so and so, and I made it very clear that, courts would take that information and say, well, you recorded it post the event, and therefore we'll take that as evidence that you, obviously the other side can produce something, but it's all evidential. Have I made it clear in a meeting, this is an idea that I think is confidential, this is an idea of an invention, the invention has a patent pending, It's that type of approach, making sure that you've expressed what you're doing, and then hopefully having the evidence to back yourself up. That's the trick.
Paper trail again.
Paper trail, it's a very easy thing. You see, what is a contract? You can have a contract without having a written piece of paper, but it records the terms of agreement between the parties. That's why anybody says we should always put these things in the bottom drawer afterwards. I say, well, why? Because that's the record of what you agreed. So.
Okay, so looking now at, you've advised many large and smaller companies over the years. In the negotiations where you've sat with a corporate and a startup, what are the things that you've seen most commonly go sour? So what are the things that, obviously without disclosing confidentiality, but what are the things that in those, small, large player, what are the things that you've seen go wrong?
I think before you even get into the intricacies of legal terms, I think one of the first things I'd say to a startup is understand who you're dealing with in a corporate, because depending on the size of that corporate, the decision making will be different. You may have procurement on large scale. It might be that you need to be talking to the commercial team and the procurement team and legal, and make sure all of that's joined up. Understand how that organisation works, I think, and don't be afraid to ask some questions about that and who the decision making power lies with, so that that you can streamline the process a little bit. I think startups are always quite surprised that things get bogged down in procurement, because they haven't understood the process of the entity that they're dealing with.
Can then get frustrated.
Yeah, and it can, in that length of time, it can be really time.
It's resource intensive for the startups. It's you don't have massive teams that you can just dedicate to cultivating a relationship and sending more and more responses to the request for information. So that's actually something that we've come across. We recently did a very small study on our startups and how their negotiations with corporates were progressing, and that absolutely mirrors what they were saying, or at least one of the things that they were saying. It's very time consuming, and you need to know who you're dealing with.
And to factor that into your pipeline, in your own sort of sales and deal flow, so that you factor that in, because obviously if it takes 6 months to get through a procurement process, and that's the only thing you've been focusing on, it can make or break a startup. So that is a very sort of broad comment. In terms of the sort of the key sticking points we find are levels of insurance. I think Chris mentioned a whole raft of things. Levels of insurance cover that a large corporate might expect a startup to have, and so really making sure that you have sensible conversations with the people that you're dealing with in the corporate, so that they understand effectively the size of company that they're dealing with and what your current levels are. There may be some cases where you need to up that cover for a particular transaction if you want to deal with a bigger corporate, but a lot of the time that will come down to a risk assessment on the corporate as well, and they have to take a view on what they're prepared to deal with. But that's an issue. I know if I just talk about the provision of IT services, the biggest area of failure is usually around over-promise, under-delivery, and that can work two ways. But it comes down to a look at the three main commercial elements: scope of work, price, and service levels. You might not have service levels, but it's that service, it's that anticipation of a level of service. But more often than not, it comes down to disagreement about who was meant to do what, who's responsible for providing what, and whether it was in the price or not. That could cover 90% of the IT services gigs that I see go wrong.
Again, something that one of our corporates has suffered in the flesh, and they are having to probably actually lose money on something that they've signed. It's going to be good for them anyway, because they'll get the pilot and they'll get the data and they'll get the reference. But that's again something that companies that we're working with have seen. So absolutely,
it happens amazingly often.
And liability clauses are
a sticking point.
But not.
It shouldn't really cause a deal to crash, because that's a risk allocation issue.
So liability clauses, tell us a little bit more about that, because again, some of our founders won't necessarily be familiar with them.
Usually they're headed up limitation of liability. And what these clauses are meant to do is apportion risk as between the parties. So under English contract law, there are certain elements of common law that liability for the provision of goods and services that you can take out. So I can exclude my liability for loss of profits, for example. Or if I've written it in, I might include liability for loss of profits. So if I, as a corporate, lose £100 million, say, because I'm purchasing a trading system and I'm a bank, and I say loss of profits will be recoverable by me in the event you don't do what you're supposed to do, Mr. Supplier, then there's an issue, and that's a huge amount of money. And loss of profits is one of those areas under English contract law that you can exclude. So it's an allocation of risk as between the parties. You can exclude lots of things. You can put caps on liability. You can cap different bits of liability. It's important.
And take out insurance, obviously.
Well, yeah, insurance will only cover so much.
All right.
Professional indemnity insurance, if you're a service provider, yes, you can take out that insurance. But your insurance company would want to know, for example, what are in your standard terms and conditions when it comes to the sale of goods and services? How do you do these things?
Okay.
Do you limit your liability? And of course, if you're a supplier, it's always a good idea to think about doing so, because otherwise it's unlimited. So yes, it has a monetary impact if things go wrong. It's and as I said before, it's an allocation of risk between the parties. But actually, when you think about it, that is a commercial decision rather than a legal decision. There's a huge amount of contract law about limitations, exclusions, what you can write, how you write it, how it's drafted, and how it's interpreted by the courts. But ultimately, it's a commercial decision about how much money am I being paid and how much risk do I take on board.
Okay. Now, the corporates can deal, or rather, the startups can deal with corporates in all sorts of different situations. They can find themselves across a negotiating table, in an acqui-hire, in an outright sale, in a purchase of goods and services. Before they sit down to negotiate, are there any common things that they should have thought about before going into the room?
What they want, objectives. Again, I spend quite a lot of time with corporates, mainly more than startups, but thinking about and asking, what do you want to get out of this deal? You know, what do you want to outsource, for example? What parts of your infrastructure do you want to outsource to a third party? What parts, how much money do you want to make out of the provision of these goods and services? What's your software licensing model? Is it a one-off payment? Is it a monthly payment type thing? How are you going to deal with maintenance? Is your warranty? It's also, what do you want to do? What are your objectives? That is the first point.
And also, for a startup, typically you've got more than one founder, and so talking quite honestly about the shareholder objectives and the founder's objectives is quite key, because we see it quite often where companies go into something like a potential sale of their business and find that actually one of the key stakeholders doesn't want to sell and wants to stay, and will have a different idea of what the future looks like. And so it's about managing that, because then that can inform how you position the business and the sort of partner that you find who will be happy to look at accommodating that, if you like, or the differences with certain people staying on and others saying, oh, actually, I'm out now, I want to sell and I want to go off and do something else. So it's about thinking about what's best for the business, but also about what the key sort of drivers are for the team, the management, owner, managed team. Yeah.
That's quite an interesting one, because again, if you're going with your co-founder, you're there with people who have done this 100,000 times before. They're going to be very well versed in negotiating and putting as much on the table as they want to. You, on the other hand, are there again with your co-founder. You're trying to do things a little bit on the hoof, trying to not show that you're as inexperienced as you are, and you're also trying to read what your co-founder might want or not. Do you have any tips or tactics that they might use, or when they're in those kinds of situations, that might let them go away saving face and think, okay, now we need to get our lawyers to look at this?
Absolutely. So I think don't agree to anything.
Look as though you have.
So I think
that's interesting. Let me take that away.
Yes, I think it's important that before going into those types of meeting, that the founders have had those conversations as between themselves in the first instance, so they kind of have a good understanding between themselves of where they each sit. And then, equally, when you're going into meetings and proposals put forth from the business on the other side of a transaction, that you have time to say, we're going to take that away and reflect on it, and we'll come back to you and we'll take some advice as well, and that's perfectly reasonable, and nobody expects you to kind of sign in blood on exactly there and then. So I think it's just about communication really, as between the team, and then how you sort of manage that, and also it's quite good from a negotiating position too, not to appear too keen. If there's a deal on the table and you want it, to make sure you're getting the very best terms for that deal. And so taking some time to reflect and looking at different alternative structures that might be, might suit you better, and you take the time to speak to a mentor, if you've got a non-exec on your board, for example, who can, with some experience in these matters, who can sort of provide you with a bit of advice, or speak to your lawyer or your accountant who will have come across these sorts of things more frequently.
Yeah, I think it's very important not to be rushed. You walk into a meeting, you need to be prepared. You need to have one set of objectives. You will stick to those objectives. If there are any issues between the co-founders or anyone on your side, you take time out. You go out of the negotiation room. You call another meeting. Don't do anything in a rush where you feel unprepared, where you feel under pressure, because usually those sorts of things go horribly wrong. It's when you're in control, when you understand, when you've got consensus on your own side, and you know where it fits into your overall strategy. That's when you say yes. That's when you agree.
I think that's easier said than done, because when you've got a huge household name across there, and they said, yes, you are fantastic, we absolutely want what you're offering, just sign here,
Yeah, but these guys got their own incentives. From a procurement perspective, they have incentives to save money. They have incentives to do various things, and what they are saying is there to meet their own particular individual agenda in relation to their own remuneration package, and for that corporation. So they might be saying all of these things, but I pretty much guarantee that they don't really mean it.
And on that point,
sorry.
On that point, now you've got corporate clients as well as startups.
Yes,
So is there any advice that everything you've said, is there anything that you would say differently if it was the corporate in front of you? Is there any tips that you'd give the corporates when dealing with the startups?
Yeah, I think the use of standard terms and conditions and procurement terms and conditions for startups sometimes is grossly inappropriate. I mean, why would you give a startup £1,000 agreement and say sign that? Otherwise, you're not going to get a deal. I have to say, most corporates I've worked with are pretty understanding of a startup's position in life, and they're not that mean. I mean, I also do a lot of stuff with the government, and actually they're very supportive of startups and small and medium enterprises, and they want all of them to do these things. So that dumping a £1,000-page document on the table is not something people should do or be keen to do. Certainly understand who you're dealing with. If you're going to ask for £10 million worth of professional indemnity insurance, and that's going to break the deal, then why are you doing it? Because they probably haven't got £10 million worth of professional indemnity insurance.
And
payment terms and things like that. We say, well, you might want to consider, 90 days is probably not a particularly fair term to try and put in, when you're dealing with a startup, because it can make a break.
VIP is unreasonable because,
And those, from my experience, those large corporates that get the best out of their engagement with startups are those that really are doing it for the right reasons, and so they have a separate division within that large corporate that is focused on how they interact with startups and how they engage, and so there's a different mindset. There's a more entrepreneurial kind of.
What is the aim of us engaging a startup?
Exactly.
What are we trying to achieve? Because you don't want to set everyone up for failure. It's just to write it down and make sure it's very clear what you expect startups to do, and they are capable of doing it.
And on that, what do you, because you're talking about the aims of the corporates as well, what do you think about corporate incubators? I mean, there's been a huge rise in the number of corporate incubators. Do you think they understand startups better? Do they actually make the whole process of negotiating with startups easier for startups?
I think it depends on the incubator. I think there are examples and stories out there of some that are more successful than others. It depends what success means as well. And so, success for whom exactly? Because there are some corporate incubators who are very good at taking in startups and funneling them into what they want to get out of the end of it, that is something that is just there to service their business, which isn't necessarily the best for the startup, because if they have a pretty wide range of things that they can offer and they get funneled into down here, then if that opportunity at the end of it is fantastic for the startup, then great, and they may not have got there otherwise. But I think there are some things to be concerned about, and to make sure that you really understand what you're getting into, and you don't end up being a funnel for one particular corporate's.
Yeah, I think the best corporates
benefit
that operate in this area are the ones that don't try and squeeze small companies into being a mini part of themselves. So I would suggest you don't try and crush them under the weight of all the corporate policies and procedures that you've developed over the course of the last 100 years, because that's really not the point. And I've seen that on a few occasions where corporates have we want to be agile, we want to get young small companies in, and we want to get them to do nice trendy things. But you've got to read this pile of information about how you're going to be part of X, because we've been doing it this way for 100 years. And that's really not what it's about.
Culturally, the fit
different.
can be a bit mismatched. And so, it's understanding what that particular corporate is seeking to get out of it, and whether there's a culture, a kind of startup culture within that corporate, because that's really important. The ones that have got some real brand advocates for startup culture within the large organisation are more likely to be a successful match and more aligned.
Okay, well, thanks very much. I'm going to now read out some of the questions from the startups, because they've been busily writing things. I think some of the questions we've been or you've answered as we progress in the discussions, but here's was one coming back to NDAs. As I mentioned, it's something that really is at the top of mind at the moment. At what point in the relationship should the startups consider NDAs?
I would say right at the beginning.
Yeah.
Okay.
If not at the first meeting, then certainly at a second meeting where you think there's going to be follow-on activity.
Yeah.
But as close to the beginning as you can.
Absolutely, and certainly before you tell them anything that you think is particularly proprietary in nature, that maybe gives you that first mover advantage or has some value to it. That I think there's nothing to be ashamed, as we talked about earlier, of being quite sort of cards on table and saying, we really want to discuss this very openly with you, and in order for us to do that, we've got to blame it on the lawyer. We've got to
that's a good one.
Slightly always happy to take that.
I'm sure nobody wants to do that. Blame it on the lawyer.
Got a slightly overzealous lawyer who said, I have to get everybody I talk to sign up to this, and you just bring it out in the open right at the beginning, I would say, and then you say it will enable us to have a much more frank and open discussion.
Okay. So, Louise, I know you, Chris, Startup Scaleup a little less, but we've got startups from all over the world, or founders from all over the world. And one of the things that they're wondering is there's a lot of cross-border dealing, startups. We've got Israeli founders, we've got startups that the founders can be forever, but they set up in Spain. So, for example, a Spanish startup and a UK corporate, is there anything there particularly that they would have to be aware of in those cross-border transactions?
I think understanding the law and jurisdiction that is governing the relationship between those two companies is key, because if you're a Spanish startup and you're interacting with a large UK corporate and they give you their standard, 100-page document to sign up to, it's having an awareness and taking some advice as to, what does that mean for you, and making sure that you're not inadvertently agreeing to something that you have no idea what the ramifications are going to be down the line and whether you can deliver on that.
Yeah, I mean, a legally binding non-disclosure agreement will be subject to the governing law and jurisdiction of a country. In that sort of cross-border thing, the idea really from if you are a Spanish company doing business with a big UK corporate, you would probably, the UK corporate would say it has to be the laws of England and Wales. And from a Spanish startup's perspective, it's not a bad idea to have it subject to the laws of England and Wales, because in that jurisdiction, that's where the corporate has all of its assets, and therefore, if you are going to sue, you sue in the jurisdiction where you have assets to enforce that.
That's a very good tip.
Yes. Yeah.
So make sure.
Okay.
So they breach the terms, and then you've got something to go after.
Exactly. You need something to go after. If you, on the other hand, if it was a flip side, you've got an English startup and a Spanish company, and you did something subject to the laws of England and Wales, and that entity has no assets, then you've got to get the court judgment, and then you've got to enforce that judgment in Spain, which is possible. It's time consuming and it's more expensive. But then think about other jurisdictions where you'd be doing business, because if you think you can take an English court judgment and enforce it in China, for example, then that would be problematical. These things could take a very long time
and be very expensive.
And very expensive, and you probably wouldn't see a dime. So it's that.
So we take the point. You kind of, it's good to have the governing law to be where the assets are that you want to kind of go against.
I mean, typically there'll be an argument as to who's got more power in that relationship. Will have a stronger argument typically as to where that governing law and jurisdiction sits. And so if you want to try and make arguments that it shouldn't be the UK, for example, and you want it to be in Spain, you'd have to look at making arguments about where the contract is being substantially performed, etc., to try and rebut that automatic assumption that it should be in the larger party's jurisdiction.
I think that's a very good point. So we have a question from Mariano, who is saying, we're working with hardware, e-health, and sometimes distributors are requesting some documentation like declaration of conformity, EAN number, medical device certifications from the beginning. Could this be dangerous? They usually talk with EU as well as non-EU countries.
Yeah, I think in those situations, what they're asking for are safety certificates, certification that certain hardware is up to a certain standard. Hey, I mean, within that particular industry, that is probably a bog standard thing to ask for, and if those standards aren't met by that hardware, then it would be very difficult to on-sell, and it might be, in some situations, it might be illegal. But where people are asking for certain standards around, I mean, the e-health thing, medical devices, that type of area, yeah, that level of certification may be a fundamental requirement. It doesn't always happen, because when someone says, I've got to have this, you've got to meet this particular standard, then you have to understand what that standard is. Is it a legally binding standard? Is it somebody's corporate policies? Is it a guidance standard? There are a variety of standards and classifications out there. So you would just check which one that particular example fitted into.
Okay, so check whether it's for guidance, whether it's a corporate standard, or whether it's actually a legal requirement that you conform. Like, for example, some of the FDA ones, presumably, etc. Okay. Another question, payment terms. It's not easy to offer 30, 60 or 90 days payments. Are there official tools to check the liquidity of companies?
Yeah, I think there are various agencies that do all these things. Dun & Bradstreet
Yep.
I can't remember, going back a few years, maybe they've
Very
changed their name.
Jordan.
Wow, the crisis.
Who knows? Who knows? But yeah, I mean, there must be. I mean, you guys do.
Yeah, there's some, sort of credit check reference agencies that you can use to see what a company's standing is. You can look at Companies House for the latest accounts. Obviously, that gives a sort of a picture in time and not necessarily the latest picture, but some credit reference check agencies would be my recommendation.
You could have, dare I say, payment up front. I mean, you could put that into a contract. You could also ask for bank guarantees. If you're selling abroad, they would have to lodge monies at certain banks, and so if you weren't paid, then the bank would pay.
Or parent guarantees as well.
If it's a small subsidiary and a parent somewhere else is much more powerful, much bigger, much more wealthy. So there are all sorts of things you can do.
These questions are all quite interesting because these are questions by startups who are really negotiating with corporates, and they're not. So these are further down from an NDA. These are, we're actually doing business now. And it's in the nitty gritty that, as they say, the devil's in the detail. I think that's one of my favourite sayings, because it really is. And another question, for example, here is a company that's having a problem to keep a single price online with Amazon or retailers. It seems to be illegal to force a unique price. But what other options do they have to keep a strong pricing policy? So I think what the point they're making is that they want to have one product, one price, regardless of the platform. But it apparently doesn't seem to be, or seems to be against the law. I think that's the implication.
Yeah, it's competition law. Is the issue here, and it's resale price maintenance. And it's illegal to try and maintain a resale price across the European member states. Is there a way to keep a certain price for a certain type of product? It comes down into, it's quite complex area of distribution law. And so you can have selective distribution networks, for example, and a good example is things like perfumes, where it's only certain areas or certain stores that you would allow to sell your goods and services in order to try and create, and I do stress, you still can't force retailers to sell at a price, resale price, but you're trying to create a band at a higher price. But there are hoops you have to go through to create selective distribution networks. But you are effectively you're fighting against European competition law, and you need to be very careful. And you would need to get specific advice around setting up distribution networks.
Okay, that's thanks for that. So I think it's now 5 o'clock, so we're out of time. I want to do a very, very brief, very messy notes here, but I want just a brief recap of the main things to take away from the meeting today. The first thing is that do consult a lawyer. Of course, we were going to say that, but seriously now, it does. I think you've made it very obvious that it's important to have a legal team that you can consult. Go and talk to a lawyer as soon as possible, not necessarily on a I'm going to give you pay your fees for this initial consultation, but get an idea of the things on which you're going to have to consult the lawyer as your business develops and grows. It's a good idea to get a roadmap for what those things might be, so that you can tick them off the list as and when you get funds available to deal with them, and as they become more and more relevant. Memorandum of understanding, always a good idea to record things that you've agreed. The legal validity or enforceability of some of the provisions may vary, but you can leave that in a document anyway and specify some of them. Confidentiality should definitely be binding, and start the NDA as soon in the possible as you in the process as you possibly can, and make it mutual as well. You can always blame your lawyer for asking them for
that's the big takeaway.
Exactly. Specifically on the contracts, problems tend to be on regarding over promising and under delivery. So there, check your scope, your service level agreements, and pricing. Just make sure that they're all aligned. Again, lawyers can help you draw up documents, although I suspect that things like pricing and terms will be more of a business consideration.
Well, you say that.
Yeah.
So, I spend most of my time doing those things.
Really, like
Yeah.
drawing up business models
Yeah,
and
absolutely.
financing.
It's the use of language and the way
Yeah.
it all fits together with terms and conditions. That's the important thing.
Okay, but that's actually really, really relevant for a lot of, you know, all of ours are technology companies, so these things are to them. A limitation of liability is basically about apportioning risk. So look at your own standard terms and conditions and make sure those are reasonable for the risk. When you go into a negotiating or to the table, sitting across the corporate, think about what you want to get out of it. And Louise says, please talk to your co-founder as well. Make sure that you agree on what you want to get out of it. And don't feel rushed. So feel free to say, oh, it's fantastic. Can we come back to it at a later date when we've considered what you've said? And then, of course, outside the meeting, consider what other options you might have. It may be that what was at the table is fantastic and the best way to move forward, but it may be that there are other ways to do things. Actually, reassuringly, a lot of corporates don't feel that standard terms and conditions are appropriate for startups, and they are willing to be more flexible. Not all of them, but it's worth a try if something comes your way, and obviously you'll be in a much stronger position to do that if you've got your legal team behind you suggesting alternatives and workarounds. Don't become a department of a corporate. This is something I heard very strongly from you. You don't just become another. That's
when you're an incubator, right? So you don't get squashed into being a smaller department within a large corporate.
And
unless you want to, of course, and it's totally up to you.
Well, I suspect that a lot of our founders could be working for corporates if they wanted to, but have chosen this route.
Exactly.
And very important to understand the jurisdiction of the contract, and that should, or one of the ways in which you might choose that jurisdiction is where the assets of the corporate are based. So thank you so much, Louise, Chris. It's been fantastic to talk to you.
Thank you.
And thank you all for being there.